on what they can say. As you know from their intros, many of them are lawyers and judges. There are attorney-client privileges that lawyers must preserve, and judges have to abide by the Judicial Code of Conduct, which prevents them from talking about issues that are in front of them. So do be mindful of that as you are listening or asking questions. I also encourage you, as you are thinking of questions and writing them on your note card, if you have a question for a specific person on our panel, if you would note that so that we don't ask the same question of all of our panelists. But with that, we are going to get started. There are lots of terms that we use in our legal system, in the justice system, that those outside the justice system may not be familiar with. And so as a way of level setting our conversation, I'm going to start by asking some of the panelists to define some terms for us. So Mr. Merriweather, I'm going to start with you and ask you to give the audience kind of a snapshot of the grand jury.
In the state of North Carolina, there are a couple of different ways by which the prosecution can decide to pursue criminal process for a felony. And one of those ways is by seeking an indictment. Indictment is a formal charge or a formal allegation of criminal conduct. The way that a prosecutor will secure an indictment is by seeking one from a grand jury. That consists of, I believe, 18 citizens drawn from your county, Mecklenburg County. And they meet every other week, once, where they determine whether or not there is probable cause that the charged criminal conduct actually took place. In the state system in which I work, a prosecutor is not present. There is only a single witness that is submitted to go before that grand jury and offer some evidence of probable cause for each and every element of a crime charge. If a grand jury amongst themselves agrees that such probable cause exists, they return what's referred to as a true bill of indictment. If they decide that probable cause does not exist, then the indictment is commonly referred to as being no bill. Now, the fact that they do not return a bill of indictment or no bill of indictment does not mean that there can't necessarily be criminal charges. The state has the right to, again, send it to another grand jury panel. In Mecklenburg, we tend to have a couple of them. However, it's safe to say that any prosecuting agency would be wise to take at least something from the notion that 18 people could not agree that there was even probable cause when a prosecutor ultimately will have to go before a jury of 12 and meet the highest burden in our law, which is proof beyond a reasonable doubt. So I hope I've explained to you at least some sort of bright lines of what the grand jury process is in the state of North Carolina.
Thank you. Mr. Smith, does it differ at all in the federal system?
Yes. In the federal system, it's a little bit different. A grand jury not only charges but also investigates. And I think this is pretty much universal in the United States. A grand jury is typically between no more than 24 people, but at least 16 people. And when they vote, it has to be a majority. When we're seeking an indictment, it has to be a majority. But also, in like the state system, the prosecutor is present. We ask for a true bill. But also, our grand jurors, and I think it would be important to say in a case like this, particularly as shown in the film, is a federal grand jury can also, on behalf of a request of the U.S. Attorney's Office or a federal prosecutor, can also send out subpoenas. For example, if they're witnesses, we want to lock in their testimony under oath, we can send out subpoenas. We can also send out subpoenas for, say, in a white-collar case, documents. If, say, for example, in a forgery case, if we want someone's handwriting, we can require them to come before the grand jury and give either handwriting, DNA. So it has an investigative function as well, which is a little bit different, perhaps, than the state.
Thank Thank you. Mr. Merriweather mentioned the term probable cause as a consideration for the grand jury. I'm going to ask Mr. Ferguson, can you give us a general picture of probable cause, what that standard is?
Well, actually, I've been trying to figure it out for the last 50 years. But basically it means that there has, in order to establish probable cause, a prosecutor, grand jury, whoever is the charging party, has to be able to produce some evidence that points to the likelihood that the defendant likely committed the crime. It is not, as many people get it confused, it is not a determination of guilt, because guilt has to be determined by a jury of 12. But in order to bring someone to trial, to put them through what it means to go through a criminal charge, indictment, or whatever the charging papers are, then there has to be something more than just a vague allegation that this person may have done something, but an establishment that there is evidence that establishes that there is at least a reason to put the defendant on trial.
And then when they get to trial, when that has happened, Judge Diaz, could you explain to us perhaps the difference between a trial jury and a grand jury?
So I'm now on an appellate court, so it's been a few years since I've been a trial judge, but essentially once the indictment is issued and all the pretrial proceedings have been completed, the Constitution of the United States requires in different sections of the Constitution, Article 3, the Sixth Amendment, and the Seventh Amendment in civil cases, that a defendant, if he so chooses, is entitled to be tried by a jury of his peers. And in North Carolina, that's a trial by 12, although in some states you can be tried by less. And in the federal system, and most recently in the North Carolina state court system, you can opt not to be tried by a jury, instead to be tried by a judge. However that decision is made, the prosecution has to prove guilt beyond a reasonable doubt. In our system, we believe that it's better that 100 guilty men or women go free than that one innocent man or woman be wrongfully convicted. And so we require a very high burden of proof by the prosecution. The defendant has no burden. It's the prosecutor's burden to prove each and every element of the offense and convince that jury of the defendant's, that peer group, of the defendant's guilt beyond a reasonable doubt. And that's a very high burden. It's intended to be a very high burden. In contrast to the grand jury, which, as Mr. Ferguson, Mr. Smith, and Mr. Merriweather just explained, where you simply have to find that there's enough evidence to go forward with the trial. So two different burdens, and we impose that burden on the state because we want to be sure, as I said, that we don't wrongfully convict somebody. And unfortunately, it's not a perfect system. Sometimes that happens. But the goal is to try to avoid that situation.
Mr. Hill, could you perhaps put a number or a percentage on the proof requirement and distinguishing between probable cause and reasonable doubt?
I know Fergie says he's been working at this for 50 years. I've not been at it for 50 years. But it is hard to quantify the difference between reasonable doubt and probable cause. Yeah, as a defense lawyer, reasonable doubt to me is just shy of 100%. And by that I mean, it's got to be very convincing evidence that the person is guilty. And the law provides several elements for each crime and puts the burden on the government to prove that. And so the role of the defense counsel is to make sure that burden is carried. When I say close to 100%, by that I mean, if you can give a reason why you think the evidence falls short, well, then that's what the law requires, a reason to doubt. And I'm one of the sort of last defenders of the O.J. Simpson result, because when you sit as a juror, you're instructed by the judge, that if you can give a reason to think, a reason to doubt the guilt of the person sitting in front of you, well then that compels a not guilty verdict. And what these jurors in California had was a whole history of police corruption, of police discrimination, of cheating, of stealing, evidence that could prove the innocence of the person brought to the bar. And you had a witness testify who was impeached with all sorts of racial disparate conduct, racial animus, history of racism, and this is the lead detective. So, when I look back at that case, as divisive as that case may be to many, and to many of the people who have diminished the work of Johnny Cochran in that case, to me what he did was hold up in a very important way the fundamental principle of our court system. This is an adversarial system. We think the truth comes to light by the two sides going against each other. And what happened in O.J.'s case, and what doesn't happen in the cases of many of the folks that we call neighbors and friends, is that our side, his side, had the resources to meet the government side and to demonstrate that reason to doubt. So I see that as one of the most important principles that underlie our justice system, one of our strongest protections, and I'm sure we'll have more opportunity to talk about that during the course of the conversation.
Yes, we will. And last but not least, in terms of definitions, if you are unhappy with the outcome of the trial court or the trial jury, Judge Diaz, you mentioned that you sit as an appellate court judge, so will you explain for our audience what happens at that level?
So, by statute, every defendant who's convicted of an offense, a criminal offense, has the right to an appeal. And so in our court, we are the first line of appeal for convictions in federal district court. In North Carolina State Court, it's the North Carolina Court of Appeals, and then North Carolina Supreme Court. And it's a very different process. The trial is over. The prosecution has prevailed despite the best efforts of lawyers like Henderson and Mr. Ferguson. And the question is what to do about that. And what to do about that is the appeal, where a defendant is again entitled to have a lawyer to write a brief arguing why mistakes were made at his trial or her trial that made a difference, that somehow affected that result unfairly, and require that the result be overturned. It's by definition a very difficult thing to do because we place a high value in the jury results. But of course, appellate courts are there to make sure that a defendant's rights have been properly preserved and that nothing has happened that has somehow altered the result and made it an unfair result. There are no trials. It's a hearing in front of a panel of judges. The lawyers submit briefs. The judges consider those briefs. They will sometimes hold an oral argument where they will hear the arguments of the lawyers, and then they will write an opinion that either affirms or reverses or does something with respect to that case that resolves that appeal. And that's how that process works. Beyond our court, the last stop is the United States Supreme Court. And that court only hears about 60 or 70 cases per year across the country. So in actuality, our circuit courts are the last stop for criminal defendants who have been convicted in federal court. The last opportunity to try to convince someone that either they were wrongfully convicted or something happened in the process that requires that their case be heard again.
All right, thank you. So I think we are going to, that does it for definitions. We are going to stop and play another clip from the hate you give, and then we are going to get deeper into our conversation.